No. Okay.
Especially just one breath away.
Okay. All right, you three ready?
Yes, sir.
Just want to,
And-
no, hold on.
Wait, are my objections noted, or do you want to object again when she offers the exhibit? Or is it already admitted, or have we?
No, we haven't admitted it.
You already pre-admitted.
We haven't admitted it.
Okay.
She has to run through everything.
Yeah, I just want to make sure where I was at.
No, we haven't admitted it. We haven't admitted it. She has to run through everything.
Well.
Okay. Then, we're ready to bring in the jury?
Yes.
Judge, I'm sorry, can I have just a moment? I'm sorry, it's a family emergency.
Yes, ma'am. Mr. Giebert and Ms. Brown, Giebert for the state, just want to make sure that you all know we are live streaming today.
Well, you told us yesterday.
I know, I told you, but
Thank you.
given the context of this, I don't think that I can emphasize it enough.
Or Judge, I'm always streaming.
You are?
I gotta see what I look like, you know?
He had his makeup artist, retainer now.
It's in the budget for fiscal year 2024.
You're being like super lawyers, you know.
You need something?
We need to take a break?
We're not opposed to 15 minutes, Your Honor. State.
Take the jury back. Carver, are both those cups yours?
They are, one's coffee, one's water.
Okay. Did you work last night?
No, but I stay up late on my days off even, so
Okay.
didn't get very much sleep.
Guess your body's just on that
It is, yeah.
sleep pattern.
I was up to like watching the Olympics.
Did you watch the men's gymnastics team?
Today.
Did you cry?
We're not up to that. There's something this year.
I'm sorry?
So I'm trying to think if there's been anything this year that's like really. moving. That one was just fun. Just like they were cheering more than the first place team just by getting behind.
Right.
Just because it's been like 16 years. since. So,
Who won?
I think China did. I have to double check. The problem too is that I see everything on Twitter first, and so then I just go back to like actually watch it.
Right.
So one of these days I need to just not, so I can be excited. And
That would have been a fun one to be watching live. Especially the way it ended with the guy on the pommel horse.
Oh, yeah. And that's the only event he did, was just on horse.
What's today? Is it women's team?
Yeah, they're around 11:30, 11:45, something like that today.
The part of missed it, but the US women's rugby team is from New Zealand in the semis. So that's stuff was something like that.
What time is that?
This was at 9:30.
They played at 9:30 this morning?
Yeah, so they played 4:22. They're probably already done, because rugby sevens matches only last 14 minutes.
I've only seen one highlight, and there was someone from the US team that's the star.
Yeah.
That was just rolling.
Yes. I
Over
forget how to
people.
pronounce her name. Her last name's like Mar or something.
She looked impressive.
Yeah.
Thank you, Judge.
Sure you're ready?
Yes.
All right.
Are you gonna give the curative instruction first, Judge?
Thank you for the reminder. Anything special in the charge that you all can think of while I'm working on it?
It should have a deadly weapon question as well. Other than that, it's pretty generic.
All eyes to the jury.
You may be seated. Thank you for your patience, ladies and gentlemen. Sometimes we have to take care of things in here. Just beg for your patience going forward if that comes up again. State, you may proceed. One moment. The last statement you heard from the witness, you will not consider, do not consider the fact that a person has been indicted, charged, jailed, or otherwise indicted in this case. You cannot assume any guilt or infer any guilt from those circumstances. State, you may proceed.
Officer Sarver, have you had an opportunity during the course of your investigation to review multiple phone calls involved in this case?
Yes,
Were you able to identify the parties on those phone calls?
I was.
And based on the context of your entire investigation, are you comfortable saying that the calling party on what will be marked as State's Exhibit number 13 is the defendant, Stacy Smith?
Yes,
And just so that there's no confusion, can I approach the witness?
You may.
Officer Sarver, during the break, did you have an opportunity to review State's Exhibit number 13?
yes. I did,
The recording?
yes.
Who is it that you actually hear on this recording?
You hear Stacy talking to his sister and mother.
And based on the context of that phone call and others, does it appear that they're discussing, amongst other things, this case?
Yes,
Does it appear clear that there is a relationship between Stacy and Karen Conscious?
yes.
What was the nature of the relationship as you understood it?
Volatile.
Had there ever been a dating relationship between the two?
Yes,
And does State's Exhibit number 13 give us kind of a small flavor of a bit of that relationship and the nature of it?
it does.
Your Honor, at this time, I would offer State's Exhibit number 13.
Check, Your Honor.
Overruled. State Exhibit 13 is admitted.
Commissioner Bublish?
You may.
Would it help if I turn the volume on? Hello?
Yeah, so, if you can, just get your Facebook back for the time being and
I deleted it for good. I don't have it no more.
I'm gonna pause it here for a moment. That first male voice that we hear on the phone, who do you know that to be?
That's Stacy.
And how about the first female voice that we hear on this phone call?
That's his sister.
Would that be Billy Smith?
Yes,
oh, shit.
I deleted my Instagram and my Facebook. I haven't been on it in almost a month. I deleted both of them. I deactivated deletion.
I decided to do something about Karen.
And do what?
Reporter.
Reporter for what?
About the cell phones.
Pause it for a moment there. What did the defendant tell his sister that Karen should be reported for?
cell phones, which I can go into further detail if you want, but
Okay, well, we'll try to figure something out.
That way she'll be in jail, she can't show up for court then. Report her.
Where is the court?
Look, I have an arraignment on the 31st. I go over there and tell them if I'm guilty or not guilty.
Well, you're not guilty, because
Let's stop it there for a moment. Do we hear a different female voice?
We do, that's his mom.
doesn't make no sense is when she filed that police report when was it that same night? And she bailed you out, she was
What did his mom have to say about Karen just there in the phone call?
Said we were there with her that same night.
on the bond release thing. Me and her, but she was the primary one. She went up there and she bailed you out.
You know, so I need an attorney, or they gonna be coming here, so I'm trying to tell you, but
Where she bailed you out. So somebody that's free for their life, how do you go up there and do that? No, that's what I'm thinking. They took a copy of a copy of our driver's license. So somebody that's free for their life, how do you go bond that person out?
that's what I'm saying. She's crazy too. Alright, well, I'll call y'all later. Don't pray for me, I'll let y'all.
Officer Sarver, at any point during that phone call between the defendant, his sister, and his mother, did Billy indicate that the defendant was with her in San Antonio at the time of this offense?
Can you say that again?
At any point during that phone call or any of the phone calls you reviewed, did Billy Smith ever make a statement, or did the defendant ever make a statement along the lines of him being in San Antonio at the time of this alleged offense?
Objection, Your Honor, hearsay is anything a third party said other than the defendant and something outside of the court. It's not contained in this phone call.
Sustained, rephrase your question.
Officer Sarver, did you ever hear the defendant claim during any of these phone calls that he was in San Antonio and not involved in a police chase in San Marcos?
I would have to listen to that phone call again. They make reference to being in San Antonio and talking about the Karen and the sister. They were talking about she was with us or we were with her.
At some point that
At some
night?
point that night.
But if Billy Smith had told officers with the New Braunfels Police Department that her brother had been with her for hours in San Antonio and could possibly have been involved in a police chase, did you hear anything along those lines in any of those phone calls?
She doesn't talk about the conversations with New Braunfels Police, but she does talk about that night in question and being with Stacy.
And so, Officer Sarver, when you listen to these phone calls, did it give you pause or make you reconsider your investigation and whether or not it was the defendant who was operating the vehicle that you saw?
No, if anything, all of the recordings that I was able to listen to just reaffirmed that fact.
Objection, Your Honor, again, not an evidence. If he's gonna go do a summary of every call he heard, that's improper.
Rural.
And why is that?
Why is what?
Why is it, if someone's saying we were with Karen Concha in San Antonio at some point in time during this incident, why would that not be consistent, or why would that be consistent with you saying I saw Karen and the defendant in San Marcos in a vehicle?
I guess I don't know where, I guess I don't understand the question. I'm sorry.
Let's maybe go back to the timeline of events. When did you actually observe the gray Dodge Charger?
It was around 8:41 PM.
And do you know when the New Braunfels Police Department located the same gray Dodge Charger in New Braunfels?
10 minutes later, maybe.
And throughout the course of your investigation, putting the pieces together, you also had reviewed a report by San Marcos crime analyst, correct?
Yes,
And you had spoken to Karen Conscious on multiple occasions, correct?
I had, yeah,
And you had actually spoken via text message with the defendant as well, is that right?
yes.
Now, first witness.
Right.
Officer Starver, I'm gonna show you what's been marked as State's Exhibit 14, 15, and 16. Do you recognize these screenshots?
Yes,
How do you recognize them?
this is the screenshots of text messages I received from Stacy Smith on my work phone.
And how do you know that it was Stacy Smith who sent you these text messages?
One, based upon the phone number in my investigation, and two, the very beginning, he says, this is Stacy Smith.
And are these fair and accurate and complete copies of those text messages sent to you from Mr. Smith?
Yes,
At this time, State would offer State's Exhibit 14, 15, 16, and tender to opposing counsel.
No objection.
State's Exhibit 14, 15, and 16 are admitted.
And it may be a little bit difficult. Can you read those
Yes.
text messages on the screen, please?
sure. This is Stacy Smith. Tell Karen to quit texting me. She harassing me and I don't care what she does. Not my concern. All this drama, but she bonded me out. If I really did any of that, why would she bond me out? She is a statement retractor and I've been dealing with this for 4 years. Ask Bear County how many charges she's dropped. Been through the same stuff with her ex, Matthew Blanco.
Did he attach a news article as well?
He did.
How about State's Exhibit number 16?
Do your research. Speak with the sergeant of SWAT team in New Braunfels. I was in San Antonio when Karen put these charges on me. Called me on FaceTime. So I don't care what y'all are gonna do because I don't have to face something I didn't do, and I'm not accepting it. So if I have to run or do what I gotta do, so be it. You can call the DA right now and let them know that I'm not showing up in a court date. Karen called the DA the other day trying to retract her statement. I'm not about to let a crazy ass bitch get me 25 to life in prison, no sir.
Was it significant to you that Mr. Smith was telling you that he was going to run or do whatever he's got to do?
It was,
Why?
because that's an officer safety issue and shows that this is something that he's capable and has thought about doing. Capable of doing and has thought about doing.
And just so that we're 100% upfront, Karen has told you various accounts of what occurred this particular evening, correct?
Yes,
She's told you that various other people other than the defendant were in the car. with
Objection,
the man,
hearsay.
correct?
Sustained.
Officer, have you ever encountered in all of your investigation any credible evidence that anybody other than this defendant was driving the Dodge Charger in San Marcos, Texas on February 3rd, 2023, when it evaded from you?
I have not.
Pass the witness.
Defense.
Officer, where does Ms. Billy Smith live?
I would have to check my paperwork to see if I had that written down in
Go ahead.
a report. Sorry that took so long, there's a lot of pages to go through. It doesn't look like I have her address in my reports.
You never went looking for her, did you?
I did not,
You never called her, did you?
I did not call her.
Didn't ask anybody else in your investigation to call her, did you?
No.
How many times have you called his mom? And his mother?
How many recordings did I listen
No,
to?
how many times have you called?
How many times have I called his mom? I have not called his mom.
You didn't follow up on that phone call or anything? You just listened to?
I did not call his mom in reference to that phone call.
You've not spoken to any of the Stanley members, have you? Actually, you personally haven't.
I personally have not.
But you're well aware that one of your assisting officers, Emily Bromfield, spoke with Ms. Billy Smith on the night of the alleged evading by Mr. Smith.
That is my understanding.
She made it clear that her brother was with her that night, right?
That's what she said.
Of interest, the text messaging you just introduced, Mr. Smith, he never tells you who's in the car, does he?
No,
And you look at your face when I talk to you? Appreciate that.
I'm speaking to the jury.
Okay. And also, he mentions to you that this isn't the first time that this girl has made these false accusations, right?
He does tell me that.
In fact, he even gives you a newspaper article, we sent you a link to it for a former boyfriend she had, that she did something similar to, didn't he? Excuse me.
He did send me a link to a former boyfriend.
That's down in Bear County, where she's the same type thing.
I don't recall where it was.
Well, did you open the link?
I clicked on the link, I don't remember the specifics of it.
Well, I think in that text message, there's also some printed portion of the article about that fellow, isn't there?
There it is.
Did you read that?
I did, it was the same thing as the link.
But you didn't go, is any part of your investigation, at least it's not documented, did you, to explore the credibility of your complaining witness, your only eyewitness to who was in that car, did you?
I am the eyewitness.
No. Who's a better witness than you? Who was in the car with the driver? Who was in the car?
Karen was in the car.
So is she not at a better vantage point to know who's driving than you?
I would say about the same as me.
I'll pass witness.
Officer Sarver, if someone makes a false 911 call, do you still have to investigate it?
We do.
Are you able to investigate reports like that if someone, the subject of which evades from you?
It makes it a lot more difficult to investigate, but we still have to do our due diligence too.
Pass witness.
Defense?
I want to talk to you about the phone call that you were speaking of with the defendant's sister and mother.
Judge is outside the scope of redirect.
Overruled.
When somebody gets arrested for the jury's benefit, you don't just get to go to jail and go home, right? You have to make a bond.
Sometimes it depends. Sometimes the magistrate can let you out on personal cognizance where you just promise to show up to court, you don't have to pay a bond, and sometimes you get a bond.
And it pretty much everybody that's charged with an offense in Texas, it's part of the process. Someone makes an accusation, warrant gets issued, or you get caught doing it on that particular act, and a warrant gets sworn out, and that person gets arrested. on those allegations, right? It's kind of the way it works.
I guess I don't understand the question, I'm sorry.
Everybody gets arrested that's charged with an offense, it's a felony in Texas. If, as part of how it starts off, how the process starts, right?
Yes,
Okay, and you either stay in jail or you get a bond posted, right?
yes, or you get let out on personal recognizance.
That's still a bond, right?
It's, there, you don't have to pay anything.
It's a bond, isn't it?
Wouldn't think it would be, if you don't have to pay anything, I don't think that's a bond.
Okay. All right, so you're not aware. So basically, the talk we hear on the call is about Karen and her, Mr. Smith's mom, bonding him out on a charge, right?
Correct, they make mention of that.
Okay. And what we hear, it's kind of hard to hear, but the mom is talking about how Karen and Stacy were together when they got arrested. Like, what the heck, you guys were together, right?
Can you say that again?
The phone call is the mother talking to Stacy about, you guys were together. He got arrested. He was with Karen when he got arrested on that warrant. They're talking about the bond, right?
I would have to listen to the phone call again, I don't remember.
They're not talking about him being with Karen in the car that night. They're talking about him being with Karen when he got arrested, aren't they?
I don't know that.
Exactly. And it's not uncommon for people to want to not have someone come lie against them in court, is it?
I'm sorry, can you say that again?
If you're accused of a crime, would you want someone to come to court and lie against you?
No, I would not.
Pass the next.
Nothing further.
And this witness be released.
Yes, Your Honor.
That's subject to recall, Your Honor.
All right, sir, you're free to go about your business for now, but if you get a call, you're still under subpoena, and you'll need to come back.
Yes, sir.
Thank you.
Thank you.
At this time, the state would rest.
Vince?
May I have just a few minutes with my client, Your Honor?
Yes, please take the jury just right outside into the hall.
Hallway.
Yes.
All rise for the jury.
Alan, can I see your exhibit, please? You just, phone call. Do you have it on computer or the phone call? Do you have it on computer or is it?
It's on the flash drive if you want to listen to it on your return.
Well, you want to leave it.
It should just be the 13th clip that's on there. There's a
What is
Stacy's
that
over
say?
13th.
Well,
It should just be 13th clip that's on there, the 13th. Yeah, the conflict.
do you ready, clip?
No, give me the Stacy's the 13th, should be the clips.
Oh, okay, I looked at it.
Yeah.
Okay, hang on. Oh, I don't have it. Hang on. I'm watching delete it. Put it around again. Are you sure you want to delete the spot? Or is it 13?
Yeah.
It's fine, I've got
do an informal charge conference. Have you had the opportunity to review the proposed charge?
Yes.
Any changes from the state?
None from the state.
Defense?
None contends.
All right, then I will print. And y'all can use the copies that you have. It's 15 minutes aside enough, given we're less than 4 hours of testimony. 15 work? You need more?
I think 15 is fine, Judge. I think if you took longer, they may start throwing things at us.
Yeah, I agree. They're ready to move. Okay, let's do 15 minutes. Ruby, let's go on the record. We're back on the record. It's CR 23-2132A. I have provided the proposed charge of the court to counsel for review. State, any objections?
No objection.
Defense?
No objection.
All right. Any corrections?
No, Your Honor.
Okay. Ms. Brown? Okay. I'm going to go print those out and we'll bring the jury in and get started with closings.
What's that? I would say so.
So you're going to divide up any of your time?
Judge, I think that state might give a brief first statement. We would just ask for the remainder of time before we start our second.
Okay. Your partner?
What?
Your partner? We got a jury in the hall.
She went to the bathroom. Okay.
Thank you. Let's bring them in, please.
All rise for the jury.
You may be seated. Ladies and gentlemen of the jury, the defendant, Stacy Sean Smith, is charged with the offense of evading arrest with a motor vehicle. To this offense, the defendant has pleaded not guilty. Both sides will soon present final arguments. Before they do, I must give you the instructions that you must follow during your deliberations. First, I will tell you about some general principles of law that must govern your decision of the case. Then I will tell you about the specific law applicable to this case. And finally, I will instruct you on the rules that must control your deliberations. General principles. The indictment. The indictment is not evidence of guilt. The indictment is only a document required to bring the case before you. The indictment cannot be considered in any way by the jury. Do not consider the fact that the defendant has been arrested, confined, indicted, or otherwise charged. You may not infer any guilt from any of these circumstances. Presumption of innocence. The defendant is presumed to be innocent. No person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The law does not require a defendant to prove his innocence or produce any evidence at all, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The presumption of innocence alone is sufficient to acquit the defendant. Burden of proof. The burden of proof throughout the trial is always on the prosecution. The prosecution has the burden of proving the defendant guilty. It must do so by proving each and every element of the offense charged beyond a reasonable doubt. If it fails to do so, you must acquit the defendant. It is not required that the prosecution prove doubt as to the defendant's guilt. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. Jury as fact finders. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony. In judging the facts and believability of the witnesses, you must apply the law provided in these instructions. Evidence. The evidence consists of the testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider, discuss, or mention anything that is not evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with this case that is not evidence in the trial. Statements made by the lawyers are not evidence. The questions asked by the lawyers are not evidence. Evidence consists of the testimony of the witnesses and the materials admitted into evidence. You are instructed not to allow yourselves to be influenced by what you may think is the court's opinion of this case. The court has no right, by word or act, to indicate any opinion regarding any matter of fact involved in this case, nor whether the defendant is guilty or not guilty. The court has not intended to express any such opinion. If you have observed anything which you have interpreted or may interpret as the court's opinion on any matter of fact in this case, or of whether the defendant is guilty or not guilty, you must disregard it. You should give terms, their common meanings, unless you have been told in these instructions that the terms are given special meanings. In that case, you should give those terms the meetings provided in these instructions. During the presentation of various video and audio exhibits, there have been portions that were silenced or redacted. You are not to speculate on what was said during those redactions. You are only to consider the portions of the video and audio exhibits that were actually presented to you. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and exhibits that are justified in the light of common experience. You may make deductions and reach conclusions that reason and common sense lead you to draw from the facts of the evidence. Admitted exhibits. You may examine exhibits. If you wish to examine the exhibits, the foreperson will inform the court of that. Only exhibits that were admitted into evidence may be given to you. Testimony. The court will allow testimony to be read back to the jury only if the jury, in a writing signed by the foreperson, 1, states that it is requesting that testimony be read back. 2, states that it has a disagreement about a specific statement of a witness or a particular point in dispute. And 3, identifies the name of the witness who made the statement. The court will then have the court reporter read back only that part of the statement that is in disagreement. The defendant's right to remain silent. The defendant has a constitutional right to remain silent. Our law provides a defendant may testify in his own behalf if he elects to do so. However, this is a right accorded a defendant. If he elects not to testify, that fact cannot be taken as a circumstance against him during your deliberations. In this case, the defendant has elected not to testify. You are instructed that you cannot and must not refer or allude to that fact during your deliberations. You must not speculate, guess, or even talk about what the defendant might have said if he had taken the witness stand. The foreperson of the jury must immediately stop any juror from mentioning the defendant's decision not to testify. Other acts. During the trial, you may have heard evidence that the defendant may have committed wrongful acts not charged in the indictment. You are not to consider that evidence. You may not consider this evidence to prove that the defendant is a bad person, and for this reason was likely to commit the charged offense. Note taking. You have been permitted to take notes during the testimony in this case. In the event any of you took notes, the bailiff will collect those notes prior to deliberations. You may not rely on your notes during your deliberations. Law. 1. Our law provides that a person commits an offense if the person intentionally flees from a person he knows is a peace officer attempting lawfully to arrest or detain him, and the actor uses the vehicle while the actor is in flight. 2. A person acts intentionally or with intent with respect to the nature of his conduct when it is his conscious objective or desire to engage in the conduct. 3. Deadly weapon means anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. 4. Now, if you find from the evidence, beyond a reasonable doubt, that on or about the 3rd day of February, 2023, in Hays County, Texas, the defendant, Stacy Sean Smith, did then and there, while using a vehicle, intentionally flee from Stephen Sarver, a person that the defendant knew was a peace officer who was attempting lawfully to arrest or detain the defendant, then you will find the defendant guilty of the offense of evading arrest with a motor vehicle and consider paragraph 5. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty and will not consider paragraph 5. Paragraph 5. Now, if you found beyond a reasonable doubt that the defendant, Stacy Sean Smith, committed the offense of evading arrest with a motor vehicle, and you further find beyond a reasonable doubt that Stacy Sean Smith, during the commission of evading arrest with a motor vehicle, used the motor vehicle as a deadly weapon, then you will indicate that a deadly weapon was used during the commission of the charged offense. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant guilty of evading arrest with a motor vehicle, but you will indicate that a deadly weapon was not used during the commission of the charged offense. Rules that control deliberations. You must follow these rules while you are deliberating and until you reach a verdict. After the closing arguments by the attorneys, you will go into the jury room. Your first task will be to pick your foreperson. The foreperson should conduct the deliberations in an orderly way. Each juror has one vote, including the foreperson. The foreperson must supervise the voting, vote with other members on the verdict, and sign the verdict sheet. You must communicate with the judge only in writing, signed by the foreperson, and given to the judge through the officer assigned to you. You must not conduct any independent investigations, research, or experiments. Do not look up any words. Do not post information about the case on the internet. Do not share any special knowledge or experience with other jurors. Your sole duty at this point is to determine whether the defendant has been proven guilty. You must restrict your deliberations to this matter. You are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. To return a verdict, each juror must agree to that verdict. But jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement, if that can be done without violence to individual judgment. During deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. After you have arrived at your verdict, you may use the form attached to these instructions. You should have your foreperson sign his or her name to the appropriate verdict. After closing arguments by the attorneys, you will begin your deliberations to decide your verdict. Signed by me, Tanner Neidhardt, 483rd Judicial District Court, Hays County, Texas. And the verdict of the jury reads, we, the jury, unanimously find the defendant, Stacy Sean Smith, guilty of the offense of evading arrest with a motor vehicle as charged in the indictment, and we further find that the defendant, Stacy Sean Smith, used a deadly weapon during the commission of the offense. If that is your verdict, the foreperson will sign that line. Or, we, the jury, unanimously find the defendant, Stacy Sean Smith, guilty of the offense of evading arrest with a motor vehicle as charged in the indictment, and we further find that the defendant, Stacy Sean Smith, did not use a deadly weapon during the commission of the offense. If that is your verdict, the foreperson will sign that line. Or we, the jury, unanimously find the defendant, Stacy Sean Smith, not guilty of the offense of evading arrest with a motor vehicle as charged in the indictment. If that is your verdict, your foreperson will sign that line. State, are you ready to proceed with your closing argument?
Yes, Your Honor, waive open and reserve close.
Very good. Defense?
Yes, Your Honor, can I get the video, audio?
Yes, ma'am.
And do you have the microphone?
I'm gonna get a towel. Is it up, Judge?
Should be. It should be.
It's not.
Everything's on.
Okay.
Don't count it as my time.
There it is.
Good work, Donkey.
Please, Judge.
That's not my screen.
That's your table.
Who's screen?
You know, it's okay, Judge. I'll just,
If you'll plug it in at this table,
their table?
yeah, we'll try that.
Mr. Gilbert, you think it's because of the displays? Right.
Whose picture is that?
Now which one is it on?
One. It's
Mr. Gilbert?
Yeah.
Can you help? It's the display settings.
What's it?
It's the display settings, and he needs to change the display settings so that what it is projecting to the screens.
We just did that earlier.
there you go.
Oh, we got it. Kudos to the state. Thank you, Judge.
Are you ready to proceed?
Oh, now, Your Honor. Thank you. Okay.
All right. You just tell me when. You just
All
tell me
right, this is awesome. Tag teaming here. Like the one. All right. What the state is so kindly helping me get up on the screen for you, go ahead and play the is an excerpt of their exhibit, a Sergeant Sarver on the highway. Note the time in which the video lasted, 2 seconds. Play it. Okay, play the second one. Second video, it's Officer Sarver's second occasion to meet the passenger and driver of the car. And note the time and the video and the visual on this one. The video is about 8 seconds, the clip on this one. With the go ahead and play.
One more time.
Yes. Okay, thanks. That's all I need. That, folks, is your evidence. That's all you have in this trial. When we talk in more dire, we talk about wrongful convictions. We talk about 3 things in particular that can lead to a wrongful conviction. Number 1 is just being a false report, okay? We don't even have a complaining victim here. You may go back in the jury room and ask, well, why didn't the defense bring that girl in so she could say that that's not who was in the car? We don't have to do that. It's not our burden. I ask you, why did the state bring the victim in to come in and say that Mr. Stacy Smith is the person who was driving the car that day? The second, more important issue here is the concept of false identification, eyewitness identification. Now, I'm not here standing before you saying that Officer Sarver is a bad police officer, that he's dishonest or anything by any means. Everyone is human, even police officers. He's not any different than any other eyewitness to a crime or an offense, right? He obviously has training as a police officer, but he's still an eyewitness. He's still a regular human person who had to make an observation. What we see here is an officer, he testified that he's on the side of the road in front of Fuego, gets the bolo, gonna pull over, actually he's a mile or so up, gets the bolo, pulls over in front of Fuego, and starts to look for the vehicle. At that point in time, all he knows is there a girl who called in on 911 saying that she's in distress, and then there's an ex-boyfriend supposedly driving the car. And so he finds the car, picks the car up. You might think, okay, well, he's on it. Go back, I urge you to play those videos over and over and over again. And watch and be that person in that car. And ask yourself, is there any way possible I could have made an ID in the car on that day? He's on IH-35. It's about 8:45 at night. You see the traffic. There's lots of traffic on there. You even see the car in the left lane passing him as he's supposedly doing all of his investigative work from the middle lane in 2 seconds. 2 seconds that he was next to the car. Officer Sarver, I asked him, what was distinctive about this individual? You may go home tonight and go, gosh, the jury was sitting next to me. What do I remember the most about that person? You know, you just met them. You actually had a day with this person. Officer Sarver had never seen this individual before, right? And he couldn't give me anything distinctive. You know, did you hear about my guy's beard? If you look at the driver's license record, he's got that on there. No mention of facial hair whatsoever. He describes him having dark, kind of long hair. Well, hello, that's not distinctive. That's just saying that maybe it's a guy, maybe it's a girl, doesn't know. Maybe it's a black, maybe it's Hispanic, wasn't sure. He couldn't tell you that. I asked him about his nose. I mean, no offense, but Mr. Smith has a pretty flat nose and a large nose. You might look at that as well. I noticed that on him. He didn't say anything about that. And then also ask yourself, what was in Officer Stryker's mind when he pulled up next to that car? Supposedly there was a firearm in the car, right? So he's driving right next to this car, and there's supposedly a handgun in the car. And he wants to sit up here and tell you that I wasn't worried about that. Sure, he was worried about that. First thing he's looking for is to make sure when he drives up, he's not going to get taken away by some thug on the side of the road with a firearm. That's number one concern. His own officer safety, as it should well be. Then what's his next concern? Okay, yeah, there's someone driving, but I don't see a girl. Where's the girl? Where's the girl? He's looking for two people in a car. He tells you when he first pulls up, he doesn't see two people. So his attention immediately goes from the driver to looking for the female. And then in all in 2 seconds. Then he pulls up. I think what he's trying to say to Sam is he's getting ready to pass him like the nose of his car, but he couldn't quite understand my question. As he's pulling up, far enough that he can no longer look through the side window, he has to look through the windshield of the car. He says that in great detail, he sees this girl, I was highlighting it, that she was in sheer terror, that her mouth was open completely, that her hands were positioned up, that she was in fetal position, she was screaming. He apparently saw her screaming while he was driving down the highway in those 2 seconds. His focus was on this girl who had called 911, as it should be. That was his primary concern when he was looking in that car, that and the firearm. It wasn't to ID the driver. And so he also talked about the lighting. The lighting is great. Well, it's not great on an IH-35. He also said that he waited until he got up to Wonderworld Drive so he could get a good visual on the license plate on the car. The contact he had with the suspect vehicle wasn't at Wonderworld. It was before Wonderworld. He even had to wait to get the ID on the license plate because of the poor lighting on the highway. So ask yourself, how great was that lighting? It was pretty good over exit 202, Wonderworld. It was pretty lit up there. But the contact occurred just past San Marcos River, okay? So, and then you ask yourself, well, why would we continue to stay with this person? He had a second interaction that night, right? The first interaction, he's looking for the car. He's looking for a gun, looking for two people in a car. Then less than maybe 2 miles down the road, everyone knows what Alton Hall is. That's where they pull over again. By then, his height was quite a bit. More anxious, more excitement. Got the car, there's two people in it, I need backup. And so the car pulls over, everyone pulls over, and it's a felony stop. Get your hands up, throw the keys out. Everyone's got their guns, they're protecting their bodies behind the door from this person, as they should be, right? And what's he looking for when he looks at that car? Is he looking to get an ID on the person? No, he's looking for a firearm to be shot at those law enforcement officers on the side of the road. That's his concern. And he wasn't with him long enough to even get an ID. Now you may go back into the jury room, and I'm not sure what kind of computer you get to play the evidence on, but like mine, you can open it up and blow it up. That's great. You say, okay, now I can see this or that. Remind yourself, on the scene, February 3rd, 2023, Officer Sarver did not have blow up zoom vision in his eyeballs, okay? The view he saw is exactly what you see on the in-car camera as it is. He didn't have the ability to blow it up on the scene to get a better visual on that. He couldn't describe anything about him when he pulled him over. Because again, his primary concern was officer safety and the safety of the victim. And then the third thing, the third eyewitness. Well, it's not really eyewitness. And do you see him in the courtroom here today? Well, of course. Who's sitting at the defense table beside the defendant, right? I would let you know that every trial has those. They're meaningless. I mean, I can put anybody next to me. Yep, that's the defendant. People don't know. I mean, that's worthless. That doesn't somehow make his eyewitness identification over a year ago somewhat more credible because he's able to identify the guy who's sitting next to me. And please take that identification for what it's worth. And then we kind of move into the investigation. The third way a person can be wrongfully convicted, if it's not adequately conducted. Now, the chase. I'm not here saying that there was not evading arrests. For sure, there was an evading arrest, no doubt. I would argue that evading took place when the car spun out its tires and entered the freeway. That's the evading, that's where it began. It continued for a while, but it didn't take much to prove that an evading arrest occurred or illegal detention. He wasn't arrested, the person driving was just being temporarily detained. So that's not the issue here. Is the issue the deadly weapon in a car? I can get up here and be disingenuous and say, well, you know, you couldn't see the driver, you couldn't see weaving in and out and everything. You know, the officer testified he was going over 110 miles an hour, 120 miles an hour easily, right? Wherever the driver was. So we're not even going to waste time on that. There was an evading arrest in another vehicle, and the person drove in a dangerous manner, endangering the officer's lives as well as other people's, including the people in the car, okay? So that's a done deal. It's all about who was driving the car. The next time these officers have an opportunity to get an eyewitness identification on who these people are in the car, it's at the house that they end up in New Braunfels. Okay, you heard testimony that Karen, the person who called in the call, that she returned to that address. That's why they went there. There was a pain, but they had been there. So Karen has lived there. Karen's been there, right? And let's just say Mr. Smith has been there before too. It's his house. So you have an eyewitness there. You got a lady who did not come to court, who the state did not present evidence of for you, who was in her camper in the driveway, like right there. So, and she had to turn the lights out right there when the car drives up. So ID's a car driving up. When asked about the people in the car, no description of the man. Zero. Description of the female? Yeah, it sounds like it's that Karen girl. Well, great. We already know Karen's in the car. She's one call 911, right? No description of anybody driving the car other than the guy. And oddly enough, also no description of any frantic, crazy, unlawful restraint, kidnapping going on either. There's no evidence of that either, which kind of makes you suspect about the caller to begin with. What do they do with that witness? Well, if they think they got their guy, well, go get a lineup. Take it to the woman. Who did you see? Did you see anybody that was there the night? Do you see them in this picture? They did not do that. That is the most reliable way to get an identification, unless you know the person, like literally know the person that you're looking at. They didn't even do that. The Bronx PD didn't do it. Hayes County didn't do it. San Marcos PD didn't do it. Nobody asked the other one to do it. She would be like crying. She's right there in the camper. She saw in the garage. She saw a person go in the house. But you have no evidence of that. You have no ID. And then they screwed up another time. You got a guy you suspect is the driver of the car. He's calling you from San Antonio later, only to show you, this is me. They had a visual that night, a couple hours later, what he was wearing perhaps, what his face looked like. They FaceTimed the guy. No description by Officer Hawks of what he saw, who he saw. He couldn't even tell you what Stacy Smith looked like on the FaceTime. No evidence of that.
Ms. Brown, 2 minutes.
Thank you. And then he goes, he talks to his sister, who clearly tells him, my brother's been all night. I don't know what's going on. He's been the whole night. Nobody follows up. Nobody investigates. Oh, it's family, so we don't care. It's not the way the law works. You have to follow your lead. You need to corroborate. If you don't want to believe, you gotta go corroborate. You gotta go find out. They didn't do that. S&P did. New Braunfels did. New Braunfels couldn't even keep their videos. 26 of them missing. No videos. The state's going to ask you to convict Mr. Smith based on his messages to the police officer, a phone call. I'm not going down for 25 to life for that lying woman. It's not exactly what he called her in his testing. I'm not going down for 25 to life for someone who's done this to me before and retracted it many times before and even did it to a different person in Fair County.
That's why that victim isn't here on stand in this trial. They don't believe her. They don't know what she's going to say. They can't even sponsor their own victim in this trial. It's not our burden to bring witnesses. It's not our burden to bring you proof. It remains with the state. Whether we call one witness, 0 witnesses, it always remains with the state. And unfortunately for them in this case, they just can't get there. They cannot prove it was Stacy Smith driving that vehicle that day. They have not brought to you the evidence that you would deserve to know about or see to sufficiently find proof beyond reasonable doubt in this case. And for that reason, I ask you to all go back there, follow the law, follow the judge's instructions, make no negative inference on my client exercising his right to say, prove it. Prove I did this. And find me not guilty. Thank you.
State?
Can I proceed?
You may.
You know, it's nice to know we can still agree on some things. We started in voir dire with these elements. And after all the evidence, the defense and the state can all agree the only question really for you as jurors to decide is whether or not the state has proved the identity of the person driving that Dodge Charger beyond reasonable doubt. That's it. Even whether or not that vehicle was a deadly weapon. Your common sense tells you that any vehicle on I-35 at night going well over 100 miles per hour, weaving through traffic, and then turning its lights off is a deadly weapon. So let's focus on the issues. And, you know, I like Ms. Brown, but I don't think she and I are ever going to work on any puzzles together. Because what Ms. Brown wants you to do is pick up each individual piece and say, can I tell what the picture is from this piece? We're looking at this one piece. And if the answer is no, she wants you to throw it away and never look at it again. But that's not how this works. What you do is you put the pieces together, and it starts with the evidence that the state brought you. If we just start with that 911 call. You know, you heard from Holly Chase, and she may not have seemed like a particularly important witness, but she told you some important information. She told you that when you call 911, your cell phone uses the nearest tower to direct that 911 call. And where did that 911 call get directed to? It got directed to the Cottle Police Department. So we have a start point. And make no mistake, I'm not here today telling you that Karen Concha is a truth teller or someone that you should rely on. I'm not doing that. What I'm telling you is that law enforcement, when they get a call like that, they have a duty to investigate, to make sure that people are safe. And that's the only reason why we get into that phone call, is because it's what starts. It's what gives Officer Sarver that lawful reason to detain the occupants of that gray Charger. And it's not a coincidence that that 911 call comes from Karen Concha's son. We know that. Hard physical evidence starts with that 911 call. Starts our timeline too. Continues through San Marcos, and we have Officer Sarver. And yes, he is a big piece in this case. He's probably several pieces in this case. And he told you, this is what I do, this is my training, this is my experience. This is why I was concerned, this is what I was looking for, this is what I saw. And I don't know how you describe someone any better than saying, it was this person that I saw. And would I have preferred that maybe he be presented with a photo lineup by another detective or something at some later date time? Sure. Maybe that would have been the better practice. But on I-35, when he knows about that 911 call and he has a duty to act, he's doing things the best he can in the time with his resources. So he pulls up next to that car, and remember, what you're watching are fixed cameras on the front of his vehicle and the fixed camera that's on his chest, not his head. Heads turn, chest can turn too, but heads can turn without chest turning. So defense counsel can talk about timing all she wants from the videos, but you heard Officer Sarver. I pulled up alongside him. He made eye contact with me. I was able to look at his driver's license photo, and I confirmed that's who I saw driving that vehicle. But at the end of the day, that's just pieces of the puzzle. You have to compare it with everything else that you've gotten in terms of evidence to say, does that make sense? Does it fit? Yes or no? Does it fit? What else do we know? We know from the New Braunfels Police Department that they ping that phone. They ping Karen's phone. And where does it ping to? His house. The defendant's house in New Braunfels. And they go there and they try to look for him. And they get there. Lieutenant Hobbs told you, as far as he can recall, everybody was at that house by 10 p.m. We know that that was after the call pinged because that ping was what told them where to go. Before that, they didn't know. They had seen that vehicle, they had tried to stop it, it evaded from them. Same consistent behavior. And you know what's really weird? When you're looking at whether or not those pieces fit together, you heard Officer Sarver describe the driving of that suspect. And then you heard Officer Rose. Two officers, different departments. Officer Rose hasn't seen Officer Sarver's video. But how did he describe that suspect driving? 100 miles per hour, weaving through traffic, turned his lights off in an attempt to evade him. Those pieces fit. And then, maybe it seemed a little odd today that we ended with that phone call, but there's those little pieces sometimes that are just so critically important, and you got one of those from that jail call. You know, there's a couple significant things on that call. Number one, if Stacey Smith were with his sister throughout this entire ordeal in San Antonio, don't you think that would have come up on that phone call? But it didn't. If Karen Concha is a liar and Stacey Smith was nowhere near her while her phone was traveling all this way, don't you think that would have been mentioned in that call? And if he's trying to put a case or charges on Karen to get her locked up so that she can't come to court, wouldn't it be a lot easier to say, hey, she lied to the police? Still a crime, but he doesn't do that. He's telling his sister, hey, look into the cell phones. So sometimes it's also what's not there that's important. But the piece that you get from that call comes from mom, and listen to it as many times as you need to. And it's clear they're talking about this case. You know that because the defendant tells you, I have an arraignment where I have to plead guilty or not guilty on July 31st. The last exhibit that you saw was a copy of the order of arraignment, which says the date for that on this case for this defendant is July 31st. No confusion there. They're talking about this incident. They're talking about Karen. They're calling her a liar. And you know what? You could absolutely believe that she's a terrible liar, and it doesn't change the fact that the state has met its burden, and the defendant is guilty. Because you've got that 911 call. And let's think about that for a minute. We like conspiracy theories these days, I think. But when you really get down to it, is there any other theory that makes sense? Is there anybody else behind the wheel of that Dodge Charger that makes sense? That makes the pieces fit? Anybody else that we know Karen Concha has a volatile relationship with? No, just the defendant. Anybody else we know looks like the gentleman Mr. Sarver says I made eye contact with and I saw driving that vehicle? No. Anybody else associated or living at the address where Karen's phone pings? No. And where does Karen end up with that night? She ends up was Stacy's mom and sister in San Antonio. You got that from that flip of a call. All the pieces only fit in one scenario. And defense counsel wants you to believe that the only time Officer Sarver ever saw the defendant was when he pulled up next to the vehicle. And it's true, that was his best look. He was less than 12 feet away and he made eye contact with the person driving that vehicle. But you know what else? If you play State's Exhibit number 4, and you'll have to right click and open with and select VLC media player, that gives you the option to zoom in. And if you do that with State's Exhibit number 4, and you look at when that vehicle stops, you'll see this. Hopefully. Well, we knew it was too good to be true. Technology working all on the first try. When you watch that clip and you zoom in, you'll see a head pop out. Can't see a lot of details in it. Video's grainy. But you know what? Officer Sarver's pretty evil eye. When you put all the pieces together, it paints just one picture. And yes, there may be pieces missing. You may have questions. You may not like how some things were handled. That is absolutely okay. But at the end of the day, the state has proven every single one of these elements. There is no other person that could have been operating that Dodge Charger on February 3rd of 2023. And if there's nobody else behind that wheel, and if all the pieces in the puzzle are consistent with this defendant driving that vehicle, your obligation is to find him guilty. And if you don't believe me, take his word for it. What does he tell Officer Sarver in that text messages? Sure, he denies it. Sure, he calls Karen a liar. Nothing new there. But what else does he tell him? What's he going to do if Officer Sarver comes for him? He's going to run. And it won't be the first time. Look at all the evidence. Put the pieces together. Take whatever time you need. But when you do that, not only will you be fulfilling your oath as juror, but you will be ensuring that that is the last time this defendant is able to try and run from law enforcement.
All right, ladies and gentlemen, you now have all the evidence in the case. You have the arguments by both parties, and you have my instructions. If you need to know anything for the case, if you have any questions, refer to these instructions. We will now be in recess while you deliberate and until you reach a verdict. You may go with the bailiff.
All right, the jury.
Okay, is there anything we need to take up on the record? All right, we're off the record. If you would give your number to Ruby so she can call you when we hear anything.
And I do have one issue. We're curious as to what you're doing regarding the state's motion to dismiss the other 2 charges in this indictment. But it was with or without prejudice.
Do either of you have anything to present to the court on that issue?
No, I don't.
I don't think anything additional, Judge.
Hey, look at the standard for when The case is dismissed with prejudice and without.
I guess we would like to.
And I'll do that now.
Thank you, ma'am.
Mr. Gibbard, thank you for taking care of defense counsel.
I know, thank you.
No problem.
No, jurors never want to see people going at each other. They want to see attorneys working together. And you did that, and it was a good, you gained a lot of credibility, I know. Thank you.
I figure out now PowerPoint.
All right, if we do get a verdict, we will be ready to start this afternoon with evidence. Y'all confer on what you need to? Turning off the audio.